There's an aspect of the Lively Baldoni case that, as an employment lawyer, has always felt off to me. And Little Girl Attorney and I have talked about this. And it's that some of the lawyers representing Blake Lively as a plaintiff in a sexual harassment and retaliation case are normally defense lawyers. In fact, they are always defense lawyers. And that's really unusual for people who work as defense and corporate lawyers in the employment space to switch sides and do work for a plaintiff. And I think I finally kind of worked out why that is. So before I say this is not a critique on the law firms I'm going to talk about or the lawyers I'm going to talk about. These are very reputable law firms. These lawyers definitely know what they're doing, even if I don't always agree with the way that they do it. This is not a slight to them. This is not an invitation to go after them or something like that. But I think that people should be able to understand how this piece of it relates to the overall picture, because it does. So Ezra Hudson is the chair of the Manat Labor and Employment Practice. And as a result, this is her bio from her website, is very clear that she is a defense side lawyer. She represents companies. She represents employers, right? She also does general counseling and things like that. But she is an employer side lawyer. That is how she has made her way in the world. And there's absolutely nothing wrong with that. But she's not the kind of person that typically takes on a case for a plaintiff in a discrimination case, which is what this is. Same thing with Stephanie Rocher. I'm sorry if I'm not saying it right. Now she, in her bio, is a little more descriptive because she says high profile individuals and corporate clients. And that's kind of where I'm going. So she has a little bit more delineation in her bio of who she might represent. But nonetheless, it still says corporate clients. Like Manat is an employer's firm, and typically the people who work there, the lawyers who work there, are doing work for employers, not for employees. By the way, if you've never looked, I never really looked at what Stephanie looked like before. She has great style. I love when a lawyer does a bio, like a headshot where they're not wearing a jacket. Like she's like, no, I'm just gonna, maybe that is a jacket, but it looks like it's a shirt. I love the hair. Anyway, I'm into her style. So typically plaintiffs' employment lawyers look like this. I have no idea who this is. I just like randomly searched in LA. This person may suck to high heaven. I don't know. But typically plaintiff side employee lawyers are small firms, sole practitioners, or boutique firms because they are representing individual people. And the reason why large law firms don't often represent individual people is because, one, they get conflicted out of that, because if they represent the employer that the employee wants to sue, they can't take the work. And number two, because a lot of corporate clients don't like it when you play both sides of the fence. So typically speaking, if you are an employee who's going after your employer, you're going to go to a firm like this. You're going to go to a small shop or a sole practitioner who specializes in representing employees against employers. And some of them are quite good. There are rare exceptions, including Quinn Emanuel, which is very interesting to me. They represent Stephanie Jones in this. Now, Quinn is a very large law firm. It's all over the place. But they tout themselves as being the only AmLaw 100 firm where they will represent plaintiffs in employment discrimination cases. AmLaw 100 is a yearly list of the top 100, there's actually sometimes they do 500, law firms in the country, and they do it by different categories, by like total revenue, by profits per partner, all that kind of stuff. So it's essentially regarded as the 100 biggest law firms and most profitable. And Quinn Emanuel touts themselves as like, even though we mostly represent corporate clients, we think this work is important, and we actually will represent victims and plaintiffs in this kind of work. They must have people in the firm who are like, we think it's important that we do this. So it's not completely unheard of. But again, this firm doesn't do that. Manat doesn't do that. Then you've got the people who are sort of the middle of the road. You've got the Friedmans, right? This is what we would call a boutique law firm, where their marketing, their brand is, we're just here to help people who are in a crisis. Like if you look at this as their employment litigation page, it's like they don't say which side they're on. They don't say who they represent. They represent whoever they think they feel like representing, right? So they're a boutique firm. Now they're probably not getting a lot of large corporate clients because, again, with the conflicts, and large corporate clients tend to like large corporate law firms, but they are not pigeonholing themselves here so that they can take either kind of case. And so it's always been like, why is Manatt representing Blake Lively as a plaintiff in this case? And the more we've gotten into the case and the more I can see the evidence, I think I understand why. And that is because to Manatt, and even to Wilkie Farr to some degree, Blake Lively as a client is a business. She has an individual issue that they are pursuing on her behalf, but they represent businesses, and she is a business. She took on this movie role as an independent contractor for a corporation she owns. She is seeking damages for 2 other businesses that she runs. Built into the case is an issue of marketing that was planned by a company owned by her husband. And as I've said before, there are, in the original demand letter, Gottlieb put in here, the firms of Wilkie Farr and Manatt represent Blake Lively and all related companies. So I really do think that the reason why these typical defense lawyers are representing her in this case, rather than your more traditional plaintiff's employment lawyers, is because to them, she is a business client. She is a client for whom they can do lots of business work. If the court determines she's an independent contractor, this really becomes a business dispute. But I think that's the reason why, and that's yet another thing that makes this case atypical. Now that can be very good for Lively, right? Because if you are someone who typically does defense work and now you're doing a plaintiff's case, sometimes as a lawyer, it's good to switch the side that you're on, because it's like, I need to alter my perspective, right? You need to say like, okay, I know what the defense, she's thinking, I know what the defense lawyers are going to do because I know what I would do, right? So sometimes that can be helpful, but sometimes it can be the opposite, which is they don't know how to do that side of the case because that's not a thing that they typically do. And perhaps that's the reason why we've seen some of these extreme efforts like subpoenaing content creators. Maybe Hudson is like, I'm on the defense side. I never do stuff like that because there's never the option for me to do stuff like that. But I've had a lot of shitty things done to me by plaintiff's lawyers, so I'm going to go balls to the wall on this one when I finally get the chance. I don't know. But this is the other thing. The reason that a firm like Manatt is able to take this case as representing the plaintiff against this defendant is because Wayfarer is not a big enough player in Hollywood for them to be disincentivized from doing it. A couple of years ago, if you just look it up on Court Listener by her name, Hudson was involved in a big case involving Warner Brothers where she represented that side of the case, as you would expect from someone who works in Los Angeles, right? So if this case had been against Warner Brothers and not Wayfarer Studios, she might have either had a conflict or Warner Brothers might have said, even though it's not direct, we don't want you to take the case. The fact that someone who typically represents companies can take a case against a company is because the company that she is suing is not big or powerful enough for it to affect her career and her other work as a lawyer with other clients, which I think is significant. So that's just a little bit of inside baseball on the lawyer thing. I think it's important for people to understand how this stuff works. And if you have questions about how law firms work, I will try to answer them. I wish I knew, did they already represent people? Do they already represent Maximum Effort? And then we'll never know that, right? Because that's privileged information. But I do think these things are relevant to the case, particularly as the case goes on in terms of why these people on this case in these positions.